Yes.
If they come over.
The Court considers that, in conformity with its obligations under the Genocide Convention, Israel must immediately halt its military offensive and any other action in the Rafah governorate which may inflict on the Palestinian group in Gaza conditions of life that could bring about its physical destruction in whole or in part. The Court recalls that in its order of January 26, 2024, it ordered Israel inter alia to, I quote, take effective measures to prevent the destruction and ensure the preservation of evidence related to allegations of acts within the scope of Article 2 and Article 3 of the Genocide Convention, end of quote.
Please be seated. The sitting is open.
The State of Israel shall, in conformity with its obligations under the Convention on the Prevention and Punishment of the Crime of Genocide, and in view of the worsening conditions of life faced by civilians in the Rafah governorate, A, by 13 votes to 2, immediately halt its military offensive and any other action in the Rafah governorate which may inflict on the Palestinian group in Gaza conditions of life that would bring about its physical destruction in whole or in part. I shall not read the introductory paragraphs of the order. In the present circumstances, the Court is also of the view that, in order to preserve evidence related to allegations of acts falling within the scope of Article 2 and Article 3 of the Genocide Convention, Israel must take effective measures to ensure the unimpeded access to the Gaza Strip of any commission of inquiry, fact-finding mission, or other investigative body mandated by competent organs of the United Nations to investigate allegations of genocide.
Par ces motifs, la Cour
The court considered that Israel must submit a report to the court on all measures taken to give effect to this order within 1 month from the date of this order. The report so provided will then be communicated to South Africa, which shall be given the opportunity to submit to the court its comments thereon. On May 10, 2024, in the present order, the court notes that the catastrophic humanitarian situation in the Gaza Strip, which, as stated in its order of January 26, 2024, was at serious risk of deteriorating, has deteriorated, and has done so even further since the court adopted its order of March 28, 2024. In this regard, the court observes that the concern that it expressed in its decision communicated to the parties on February 16, 2024, with respect to the developments in Rafah have materialized, and that the humanitarian situation is now to be characterized as disastrous. Pursuant to Article 41 of the statute and Article, the court is also of the view that provisional measures indicated in its order of March 28, 2024, as well as those reaffirmed therein, do not fully address the consequences arising from the change in the situation previously explained, thus justifying the modification of these measures. I shall also omit or summarize some other passages. The court is not convinced that the evacuation efforts and related measures that Israel affirms to have undertaken to enhance the security of civilians in the Gaza Strip, and in particular those recently displaced from the Rafah governorate, are sufficient to alleviate the immense risk to which the Palestinian population is exposed as a result of the military offensive in Rafah.